Hello everyone and welcome back to another live stream with me, Grizzly. This is Grizzly True Crime, and today we are going to prepare ourselves for the Ashley Benefield trial, otherwise known as the Black Swan murder trial, because she was a ballerina, so that's why it's been called that, of course. So if you haven't checked out part 1, it's linked in the description box. It's linked on the community tab, and I would highly recommend watching part 1. If you haven't watched it yet, like you didn't do your homework, then please watch it afterwards, because it'll give you a good foundation to prepare for the trial. That was a deep dive. Today I'm going to do a recap for you. I'm going to show you some little clips, and we're going to listen to little bits of a 911 call from the day of the crime. And then we're also going to look at 9 key moments from the pretrial hearing, instead of watching the entire pretrial hearing. As snarky as it was and interesting, I will link the full one if you want to watch the whole thing. I know some of you already have, because it happened yesterday. But we're going to focus on 9 key moments so that you can get a feel for the vibe in the courtroom. You know, so far so good. I'm loving this judge. Okay, I'm sure you will too. Rexy said, love this community. Thank you so much, Rexy. Happy Grizzly anniversary. You've been a member for 23 months. Oh my goodness. Catherine said, hello G-Mods, thank you for what you do. Thanks for being a member for 9 months, and welcome to all the new members, including V. Aguilar and everyone that joined before the live stream started. Welcome to my moderators, patrons, members, subscribers, any locals in chat, and any family or friends of the victim in this case. Now, the thing is, okay, so if you watch part 1, you're kind of up to speed of what this case is about. But there is a whole nother side to it, okay? So we've got to go into this completely. Well, I'm going to. I don't know about you. You can make up your own mind. We're each entitled to our own opinions, but like totally innocent till proven guilty. Let's see what happens in this trial, because there's a lot to the story. There's a lot of documents. There's a lot of history. There's a lot of accusations, lots of things, right? So we're going to look at as much as we can before the trial starts. Just to let you know, the trial starts on the 22nd of July, which is next week, depending on when you're watching this live stream. And that's when jury selection starts, which they think would last about a day or so, a day or two. About a day is what they said. And the trial is set to last only about a week or two. So, and it's happening in Florida. So, Manatee County, Florida. All right. So now, what I want to do first is let's do a little recap. If you saw my previous presentation from part 1, it was a much deeper dive than this, which is why I'd recommend that you check it out, okay? So, Wogger said, so torn, watch this live or go back and do part 1 first. I would say watch this live, because we're going to do a recap. And then afterwards, go and watch part 1 as homework, okay? You're here with us now. You've made it, okay? Please like and share. Watch with us now. Afterwards, go watch part 1 at your leisure. We'll meet again tomorrow, though, for part 3, so that we can go over some other layers to the story, okay? Barrett, thank you so much for being a member for 1 year. I know a 1-year Grizzly anniversary is a very cool milestone. I love that. Thank you so much. All right, so the Ashley Benefield trial. Now, Ashley Benefield is charged with second-degree murder. She shot her husband, Doug Benefield, on September 27th of 2020. So no one's disputing that she shot her husband. She's not saying she didn't shoot him at all. She says she shot him in self-defense. On November 4th of 2020, she was arrested and charged with second-degree murder. She wouldn't speak to 911 dispatchers. The neighbor did. That's what we're going to listen to, little clips like that. She wouldn't speak to the police, and she's hardly said a word in court, which I know is her right. She doesn't have to speak. It's just interesting to note that she's not saying a damn word, right? But maybe that's better for her case. As we know, she might watch some true crime. She's probably like, okay, lawyer up and don't say a word. All right, I can't really falter on that. Can we falter on that? I don't think so. It's just like she just hasn't said much. We haven't heard her speak all that much. So they said, it appears Ashley, in the probable cause affidavit, which we did go over in part 1, it appears Ashley had exhausted all legal means of keeping the child away from Douglas before the shooting. So that seems to be, I would say, that what the state is going to go for as the motive. Why would she do this? Because she was trying to selfishly, is maybe what they would go for, I'm speculating, keep their child away from Doug. We'll see. We'll see. I'm very excited to see this trial with you. So if you didn't know, yes, I'm covering the trial. We're going to be together for a week or two, every day, watching this trial together. And I can't wait to hear what you all say throughout the trial, because it's very interesting with many layers, as I say. Thanks, Sarah. So she got a $100,000 bond, which she paid. And she's been wearing an ankle monitor ever since. So you'll see her in smart civilian clothing, okay? Looking ever so elegant as the ballerina she was, right? Coming in and out of the courtroom and then going home afterwards. She stays with her mother, I believe it is. Yes, she's been living with her mother. And she also, her little girl is now 6 years old. So it's a 1 to 2 week trial, and it starts on July 22nd of 2024 with jury selection, right? So I'll be streaming in a defluffed way. If you have never watched a trial with me before, what that means is we wait for about 2 hours before we start, so that we're 2 hours behind the actual live day, so that later we could catch up by skipping over the lunch breaks and the coffee breaks and all the fluff. Because sometimes, I don't know, man, sometimes that's excruciating to just sit and stare at like ceiling fans or, you know, the back of the wall. Like, oh my word, we don't want to do that. So we're gonna do it as efficiently as we can. A defluffed trial, as we do here at Grizzly True Crime. All right, so now let's get into a little bit of the storyline here. There's a picture of her, by the way, on the right, and a picture of Doug, the victim, and her on the right-hand side as well. So here's the story, quickly. These are bullet points. It's not as deep as part 1, as I say. Ashley, 24, and Doug, 54. There's a big age gap there, yes. Met in 2016 at a Republican fundraiser in Palm Beach. Doug was a widowed Navy veteran whose wife, Renee, died 9 months prior from a heart condition. 13 days after meeting, Doug married Ashley. That's very fast. That is, wow, way too quick. But okay, that's not what we're here to judge, okay? I'm just saying, we're just like looking at all these facts, looking at all the layers, right? So Doug was a technology consultant and entrepreneur from Charleston, South Carolina. Ashley was a former swimsuit model and ballerina with a dream of starting her own ballet company. Doug helped her create the American National Ballet Company in Charleston, but then Ashley got pregnant soon after she started the company, and so she wasn't really giving it much attention, and essentially it fell apart. Which was very unfortunate, because she wanted it to be all-inclusive for people of all shapes, sizes, ethnicities, everything, and then all these ballerinas were signed up, and then it just like fell apart. And Doug was trying to run it, but he had all these other companies to run, other full-time jobs, so like, you know. Anyway, so she then moved to Florida to be with her mother while she was pregnant. She wanted to get away from him. And she gave birth in March of 2018. It was a cesarean section, and she didn't even tell Doug that the baby was born. Okay, so a nasty custody battle began. Ashley didn't want Doug near their child, and she had started filing DV claims in court. So essentially from the outside, this seems like a domestic violence case. However, she, based on what we know so far, also seems to be so manipulative and cunning and crafty that one wonders, is she abusing the system? And if it turns out to be that, that's going to be very unfortunate. However, there is some evidence that Doug may have stalked her. He admitted to putting a tracker on her car. He admitted to punching the wall. He admitted to punching the dog. He admitted to throwing a 13-year-old cat against the wall, and admitted to being violent in the past. So there's a little bit of merit there to what she was saying. But the problem is, generally, you can't just, if he was, because not here to defend himself, right? So he's the victim of this crime. But if he was a DV aggressor and coercive controller, you still can't just one day shoot him in the back. You know what I mean? Like they say, he was probably not even facing her when she shot him. That's why I'm saying there's a lot of layers here. And we're going to discuss many points as we go and prepare for this trial. So, at an injunction hearing, the judge went on the record advising that they did not find Ashley Benefield's story to possess a scintilla of truth. Now, sorry, my hair is, I hope the fan is not too loud. I've got the fan on, the door's open. Hope the cats don't bother us today. It's just so hot here. I have to. Okay, so if you see me doing this, the fan is blowing my hair. Okay, so what I want to say is the judge saying, a female judge previously, and they want that out of this trial, right? But the judge said that they don't find a scintilla of truth to what Ashley Benefield's claiming. She claimed to be poisoned. She claimed to be, a victim of domestic violence. She claimed all sorts of things, and eventually also claimed that he was harming their daughter and all sorts of things. But you know what I want to say? Sometimes we know that the court systems are not quite up to speed, if I can say it like that, with coercive control and domestic violence. We've seen many cases go very wrong. You know what I mean? So I'm just like, I'm on the fence. I'm on the fence with this one, as I suppose one should be. Color Lily says, you're fine, G. Go on, right? riveting case this. Oh man. Okay, so September 27th of 2020, that's the day of the crime. Doug Benefield arrived at Ashley's mother's house in Bradenton, Florida. Remember, he's from Charleston, South Carolina, and Ashley had lived there with him, but then she got pregnant, the ballet company fell apart, and then she packed up her stuff and went to move in with her mom. Okay, and he didn't know the baby was even born. He only found out later. Okay, so they say he then went to Florida because her mother lived in Florida. Okay, so he went to Ashley's mother's house. It was planned, 5:30 p.m., to help pack a U-Haul truck because they were all going to move to Maryland. Ashley and her mother and the baby were going to move to Maryland. But Doug was like, I'm also going to move there and we can all be a family. So already there, it sounds almost like you could look at it two ways, which is why I'm very excited to see the trial. I hope the jury gets it right. Whatever comes out of trial, I hope they know a little something about these topics, because one could look at that two ways. Number one, you could say, well, Doug couldn't let her go and he was stalking her, following her, Or one could say that she manipulated him to say, yeah, sure, come and pack the U-Haul, lured him almost to his death. There's just different ways one could look at this based on what we know so far, which definitely is not everything. Hence the trial. So Ashley said that he allegedly became angry, screaming, "We are moving together as a family, making a fresh start, but you're dividing us, and it's time you start acting like a wife." Manatee County, Florida dispatchers received a 911 call at approximately 6 p.m. from Ashley's neighbor. The neighbor relayed that Ashley said that her husband had just attacked her and she had shot him. Now, the neighbor and police officers did not see any of Ashley's clothing torn, ripped, no marks, nothing on her. So they're like, how do you mean? How did he attack you? Right? But if there's a whole history of abuse and she didn't make it up and all that, okay, we have to be careful with this one. If there is, maybe she could have seen this is now escalating and did act in self-defense. However, she ran out of that house with the gun. She ran to the neighbor's house with the gun and then immediately said, he attacked me and I shot him. So, although investigators say it looks like he wasn't even facing her when she shot him. So, we'll hear all of that in the trial. Doug was shot twice in the master bedroom with a .45 caliber weapon, once in the right leg, and the other shot went into his chest, but they said skipped his bicep. She was not a good aim, clearly. Not that we want her to be, I'm just saying she fired 4 shots. There was one in the wall and one in the door, and 2 shots hit him. So, yeah. Investigators say the evidence suggests that Doug was not even facing Ashley when he was first shot, so that's a red flag. And then also, at the time, this one is interesting to me. At the time, Ashley's mother had taken Ashley and Doug's daughter for a walk to a splash pad. I mean, okay, but it's one could look at it two ways again. Well, that's mighty convenient. Now there's no witnesses. It's only you and that man, Doug, the victim, in the house. No one, he can't defend himself now. You know what I mean? He can't say what happened. And you know what I mean? To go for a walk, whatever time that was, around 5:30 or 6 p.m., maybe the mother-in-law then would have just given them some space, thought, oh man, these two are probably going to, I don't know, argue again or whatever it is. But yet, the whole point of meeting up was to pack the U-Haul so they could all move together. So I don't know. I don't know what to think of that. Again, eager to hear your thoughts as well, especially as the trial starts and develops. I'm eager to see what they're going to say. So, here's a couple of red flags. These are Ashley's red flags, and there's many, okay? There's many for each side of this case, and that's unusual, because I'm always here for victims and their family. As always, I still am. I just don't want to be blind to if there was domestic violence, if there was coercive control. Is it a case like Sally Challen? Have you heard of Sally Challen's case? If you haven't, go check it out. It's on Laura Richard's podcast, a crime analyst. Very interesting as well. Anyway, so that was proven to be coercive control and actually led her out of prison. But she hit her husband over the head with a hammer. She said, because she snapped because of coercive control. Coercive control is illegal in many states, in many countries. So it's just very interesting. Point is, let's look at Ashley's red flags, and they are very red flags, okay? This is where I'm right. So Ashley and her mom, these are just a couple of bullet points, tried to convince Eva. Now that's Doug's daughter, who was 15 years old, I believe at the time, when they met. I think she was 18 when he was shot. Okay? So just think a teen daughter from a previous marriage. Eva was, so if the daughter was between 15 and 18, right, in that time range, okay, and Eva's like only 24 when she met the teen daughter. Well, Eva sounded a little jealous from what I'm hearing, right, of this daughter, and like, why is she here, and like trying to cause fights between Eva and her dad, kind of trying to isolate Doug by what I'm hearing. But again, it's just one side of the story. I don't know. So what I want to say is Ashley and her mom tried to convince Eva that Doug had something to do with her mom's death. Now, I think that's completely sinister and sick to do, or they're both mentally ill. I don't know what to think, meaning Ashley and her mom, because why would you do that? Why would you pull a teenage daughter aside and then say, hey, we think that your dad actually he probably killed your mom, where her mom died from a heart condition that she had, and it was Eva that actually found her. She came home from school one day. She was trying to get in the house and knocking, calling and everything, and then she saw her mom, and she saw there was something wrong. She went in the house, and she found her mom deceased. There's already enough trauma there. You do not have to conspire with your freaking mother to be like, hey, Eva, yeah, this guy, yeah, he's a bad man. Try to kill your mom. That's just so wrong, okay? Red flag number 1. Then Eva said she would kind of twist my words and make my dad get mad at me. Red flag number 2. Why would she do that? Hammy says, so happy to be a Grizzly. Thank you so much for being a member. Why would she do that? That sounds incredibly manipulative, right? So now, Ashley then said that she was being poisoned by Doug when she was pregnant. And once the baby was born, she put herself and the baby through 26 days of hyperbaric chamber treatments, which one might call child abuse. I don't know. Some people might be like, it's just being safe. Others might be like, what the hell are you thinking? She thought that when Doug had sent her a box of tea, that it was poisoned. And she thought she was being poisoned with zinc. Now, she apparently, according to documents I'd read today, had sent it into the police, and there was like a hazmat crew that arrived, and they confirmed that it wasn't tea, but it was potpourri. Was it really potpourri? I don't know. And she's like, it's very poisonous, very toxic. He was trying to poison her. Those are the claims, okay? But there was no evidence of any poisoning. So for 40 hours with a newborn, she wants to be in a hyperbaric chamber, looking if either of them have zinc poisoning. That's trauma. That's trauma for the child. Like, what the hell is she doing? And they couldn't find any evidence of it. So that makes me wonder about Ashley's mental health. Like, is she paranoid? Is she like a hypochondriac? Does she come up with this? Or was she that scared of Doug? I don't know. So, yeah, Casey said Eva is an honorary Grizzly, right? Morgan Molo said, I'm from Charleston, and the daughter has posted a TikTok video explaining the whole situation. Yes, and we posted that too on part 1. So if you guys didn't check out part 1, please do your homework. Sometimes here at Grizzly True Crime, you do get homework, okay? It helps. It helps for the foundational studies of the case before we get to the trial. So part 1 is linked for you on the community tab in the description box. There's a playlist for you as well that I've made today called the Black Swan Trial. So go and check it all out there, okay? We looked at all part 1 to 6 of Eva's testimony about what happened with her dad, with how Ashley was, all of this, okay? So you need to go and watch that. So now, here's another one. She did not list her father on the birth certificate, so she had the baby in secret. She scheduled a cesarean section. She had the baby. She didn't tell Doug about it. Okay. I think he found out like 9 weeks later, if I remember correctly. What? She listed, no, there's no father. She wanted the baby to herself. Now, again, would that be because she's trying to protect her child from an abuser, or would it be because she's completely selfish and just is done with the relationship and wants him to have no part of it? Like, as if she could just decide that, but he is the father, you know what I mean? And Eva, Doug's biological daughter as well, she absolutely loved her dad. She was so close to him. I mean, you must go watch part 1 to see how she speaks about him and everything. So, you know, I just wonder about that right there. Okay, so in August of 2019, Ashley showed up to drop her daughter off wearing an engagement ring. Like, just randomly, let's just custody exchange, you know. Here you go. Dropping the daughter off for a visit, and then, oh, wow, look at me. I'm engaged. I mean, Doug was like, what? Oh yeah, she's now with someone else. Now again, was she with someone else or was she pretending? I don't even know with Swan, I'm not too sure. But Doug then filed for divorce. And guess what she did when he did that? She then accused him of physically and sexually abusing their daughter and called CPS. And there was no evidence of abuse found. Again, I'm going to say, we've seen often in cases where CPS doesn't do the best of jobs as much as we want them to. So I don't know. However, if she's showing up with an engagement ring and he's like, okay, I'm filing for divorce, and then she kind of retaliates. It feels like a bit of a retaliation, like a revenge game of saying, okay, well, then you're physically and sexually abusing our daughter. I don't know about that. Because then why would you not just divorce him? Why would you not file for divorce? Why are you showing up with an engagement ring to taunt him? I find that interesting. Carla Lily, thank you so much for your 99 cents. Canadian, right? Thank you so much. So, Ashley then later reconciled with Doug in the summer of 2020. Okay, that's right before he died. And then she planned to move to Maryland. Like, it feels like she's playing chess. You know what I mean? She's like, okay, so that did not work. That did not work. Okay, well, let's get back together. And then let's all move to Maryland. And then one day, self-defense. Again, this is one side of the argument. We're going to look at all the sides all the time. Okay, so don't misquote me on just one side because we're trying to look at the whole picture. I'm just showing you now Ashley's red flags, right? Now, Ashley's mom is her only witness at her trial. All right. Just saying. When you look at all the state's witnesses, it's obviously all the investigators and experts and everyone. The only witness that she will have is her mom. So I don't know what to say about that. Now, other red flags, because it feels far too hurtful to say Doug's red flags, because he's a victim of this crime. He's a homicide victim, all right? So, but here's some other red flags to consider, just to try to get the full picture, right? Without any victim blaming. These are ones people, they have a problem with. 54-year-old Doug married 24-year-old Ashley. Okay, the age gap, yes, a lot of people are bothered by that. For me, the big red flag is marrying 13 days after meeting her. That is super fast. That's like love bombing. That could be signs of coercive control. It could make someone feel trapped and whatever else, right? Still doesn't mean you could just shoot them in the back, but you know what I mean. Okay, so he was deeply religious and allegedly wanted to marry Ashley to be intimate with her according to his faith. I don't know if that's a red flag or not. I'm just pointing out what people on social media are saying there's a red flag. I'm not sure. That obviously what I mean would be is it shouldn't just be a motive to get married real quick, right? It's just so that you can have sex with her. I don't think so. But that's just allegedly. Now, he got his ordained friend to marry them, okay? He admitted to violent behavior, saying during, and these are part of court records, okay? It's been transcribed. There are court records of him admitting this. He admitted to violent behavior, saying that during arguments, he had thrown a gun at Ashley. He had hit the dog, and shame. The dog is like, I don't know if it's a Labrador or Golden Retriever. I think it's like a Golden Retriever, but my goodness. He hit the dog because he was so angry that Ashley wouldn't stop arguing with him. All right, so that's very upsetting. He'd fired a bullet into the ceiling, which he said was the dumbest thing he ever did. So that's also obviously very threatening behavior, right? It's pretty violent. You can't just pull a gun out of its holster, which he apparently did, and then shoot into the ceiling to try to stop an argument. And then they say that Ashley when Ashley moved out to be with her mother, and then they planned to move to Maryland, then Doug moved there too. Could that be coercive controlling behavior? Could it be him stalking her? I don't know. Those are the allegations she's making, of course. Ashley had a burner phone and lawyers, and she was apparently trying to get away once and for all. If that was the plan, I still don't think like luring him there and saying, okay, sure, or maybe he was just there. I'm not saying she lured him there, but if she did, saying, sure, come on over and help me pack the U-Haul. And then they pack everything. Then the mother and daughter go for a walk, okay? Mother and the baby, right? They go for a walk, and there's one box left in a closet. And then they go in the house, only Ashley and Doug, and then he's suddenly shot, where there's no witnesses. I don't know, man, but okay. She apparently had this burner phone and lawyers and everything, was trying to get away from him, which we know. If it's victims of domestic violence, it takes up to 7 times to try to leave, and it's difficult, and you got to leave safely. That's why I'm saying, if that was the plan, then this is definitely not the way. This is not a safe plan at all. So we always try to learn from these cases. from either side. So note, there was no DNA evidence on Ashley to prove that Doug attacked her that night. Because days later, she had like these scratches on her side and she was showing, injuries, but they're like, what the hell is that? Apparently it was like scratches from a box or something, and I don't know. But there was no injuries or signs of her being attacked by him, like a violent struggle or something, right? Sweet Caroline, thank you for being a member for 10 months. You said, I'm late, I'll be covering this trial. We are. So I hope you'll watch part 1, because this is part 2. If you want the deep dive before the trial and to be informed so that we can actually have decent conversations. I hope we will all be there discussing this case as we go along. I think it's going to be very interesting. Okay, so that's just a quick little recap. Again, part 1 was a much bigger deep dive into the backstory, into who's Ashley and who's Doug, and into Eva's 6-part series on TikTok and her explanation of things and everything. And the probable cause affidavit is all in part 1, okay? So what I want to show you now is this. Here's another red flag. Okay, wait. Yeah, okay. This is another red flag. This over here is Ashley Benefield's daughter and Doug's daughter, Doug the victim. Okay, and you see this is another red flag to go into the red flag box on Ashley's side. Because why? Remember, she's out on bond, huh? She's living with her mom, she sees her daughter, okay? Why would you make or want your daughter to, or not even protect your daughter from doing this? You have your daughter have a sign, keep my mommy free, with all these like purple hands. You're gonna make your daughter stand outside of the courtroom petitioning for you. That is again child abuse. Stop this. Protect this child. I mean, I'm blurring her face as well to protect her. I feel protective. And I've never met her. But it's a 6-year-old little girl. Her dad was shot by her mom. Don't put her in this situation. I don't know, man. Let me know what you think of this. Let me play this clip quickly here so that you could see it. There's no sound. I just wanted to show you. Oh my goodness. I think that's super manipulative. Now, as you can see here, there are people absolutely rallying for this defendant. Petitioning, protesting, rallying, okay? And so tomorrow we're going to look at that side of the story, because it would only be fair to look at both sides, especially in a case like this, because it's very like, what? Okay, so they say westandwithashley.com is the website. We're going to look at that tomorrow. They say it's not a crime to defend your life. Seek truth and visit westandwithashley.com. All right, we'll look at that tomorrow, and some documents and some letters that Ashley wrote, so that we have a bit of a fuller picture. Just let's look at the whole thing, right? But damn, this is quite hectic. There's people dressed all in purple saying it's not a crime to defend your life. Now, one would agree it's not a crime to defend your life, especially in Florida. They do have the stand your ground laws and rules, but she did not win that. She had a stand your ground hearing for 2 days in 2023, and that was not a case that she won. She can bring it up again, but you know what I mean? She's tried everything. She's had motions to dismiss the case against her, to dismiss all her charges. She's had a stand your ground hearing, taking up 2 full days of the courtroom, and all of that. She's tried her level best to not get this trial going, you know what I mean? And there's a lot of supporters of Ashley Benefield saying, well, she was just acting in self-defense. Well, if the victim in this crime was an abuser, and at that time she actually just acted out and not in self-defense, those are both problematic. Both sides are like, oh my goodness, what's going to happen here? By the way, she faces 25 to life if convicted. So objection kicks in. Sounds like they are both abusers, but she sounds a long way from proving self-defense. That's the thing, right? Ali B from Tennessee, welcome. Yes, I'm going to be covering this trial. Please like and share so that others can learn this information today as well. And please do check out part 1. Okay, so after this, we're going to listen to little clips from the 911 call. Just hold on 1 second. I just want to show you some of the... She's standing here next to Trump because she once worked on some of his campaigns. Remember, she met Doug at one of the rallies as well. So they say never surrender. Okay, that's loud. Hold on 1 second. I just want to put this on. Okay. The reason I'm going to show you this 911 call, it's little clips that Court TV played because In the pre-trial hearing, which took place yesterday for 5 hours and 7 minutes, and unfortunately we only got to see the back of her head, I'm like, come on, man. Where's the cameras from the other side? But never mind. We're grateful for whatever we can see. They argued, the state and the defense and everything. This was the pre-trial hearing to decide on finalizing everything, right, for this trial, which is starting next week, Monday, on July 22nd with jury selection. They do not want these little bits played to the jury during this trial. So they will play the 911 call. But what we're going to listen to here now, that's not going to be played to the jury. So you are hearing now what the jury will not be hearing. Okay? So here we go.
We're in an argument.
Oh, I don't know. She came in. She was quite hysterical. I didn't know who was banging on my door.
That's the neighbor. Remember, she ran out of the house. So she shot four times. 2 rounds hit Doug. He was taken to the hospital, which is where he died from his injuries. Okay, he didn't die like at the house on the spot. And so this 911 call was when actually she shot her husband, ran out of the house with a gun. Dog walkers saw her and like, what the hell? And she's like, help. And then she ran to the neighbor, banged on the door, went inside, and you could hear her in the background. So the neighbor called 911.
Or said that he attacked her and she shot him. They've been having trouble. We need the police before her mother and the little girl gets back from the park. I don't want them to find this. I know.
Okay,
it's not what people think. It's not what people think it is. I know.
Yeah. What's the female's phone number?
I don't know. I'd have to ask her if she can try. I don't know it off.
Can I get her on the phone for a second? I can ask her myself. If you need.
Can you talk to her for a minute?
I can.
No. Huh?
I just need her phone. I just need her phone number. I'm not asking her any questions.
All she needs is your phone number.
Okay, so that's the clip. We're back here with Keep My Mommy Free, which just, this makes me upset. Zero Patience said, thanks, G, for keeping me in the loop always. It's my pleasure. Welcome to everyone who's only joining now. This is part 2 of the trial prep for Ashley Benefield. If you're watching the replay, I'm so sorry that I have to keep saying this. I know it must be annoying if you're watching the replay to listen to this over and over, but people are joining late and asking the same questions over and over. So let me say it one more time. Part 1 is in the description box. It's on the community tab. It's linked to the shorts I've made about this case, and there's also a playlist called Black Swan Trial on my channel. Okay, so those are all the places you could find part 1. This is part 2, and tomorrow, depending on when you're watching this, we'll be doing part 3 as part of our trial preparation. Yes, part 1 was a year ago, but that was such a deep dive. I can't top that. I watched my own part 1 and I'm like, oh my word, like, okay, yeah, no, I think everyone just needs to go and watch that. So part 1 is there. This is part 2. Now what we're gonna do now is watch 9 key moments from the pre-trial hearing. So let me quickly go fetch that for you. Hold on one second. We're gonna get it here. There we go. Right, so this is the pre-trial hearing. What I first did was 1 round of defluffing it. So it went from 5 hours and 7 minutes to 4 hours and 7 minutes. I still think that's a little long for today, especially because a lot of people I saw from when I had posted on the community tab, they don't know about this case. They're like, what? I've never heard of this. And okay, so people have a lot of catching up to do. So the last thing I want to do is overwhelm people with this case. I want to give you all the highlights. So part 1, deep dive. Part 2 today, we went over a case recap. We looked at some clips from that 911 call that the jury won't hear. Now we're going to listen to key moments from the pre-trial hearing and just get a feel for how this trial is going to be, because this judge is awesome. I honestly feel that sometimes, obviously, it's the judge makes the case, you know what I mean? If you have a judge that's like, I don't know how else to say it. Every case is important, but if you have a judge that like is a little bit, I don't know, tardy, boring, whatever word you want to use, I don't know. Sometimes it's like, whew, it feels like it drags on, hey? But this judge is snarky. You know, he's got strong boundary setting skills. And he's like, sorry, what did you just say? So let's start with 46 minutes. Hold on. I'm going to go 46:55, somewhere around here. There. Okay. So the judge name, his name is Stephen White. Okay, that's the judge's name. And oh man, I'm loving what I'm seeing so far from all the hearings from last year and from this now as well, the pre-trial hearing to finalize everything. All right. Judge is Stephen White. The prosecutor is Suzanne O'Donnell. And I believe the defense attorney's name is Neil Taylor. Okay. Welcome, sunshine and tan lines. Okay, so here we go. Listen to this part.
My response, Your Honor, I'm going to need a drink of water before.
Of course. Do here. Of course.
Thank you.
Sure. Absolutely.
You see, the judge is very accommodating there. Of course, you have your water. But later, he's just like, sorry, what? You know, the judge can be so nice, but also be like, don't accuse me of that. Or what are you trying to say? Like, very snarky. Love it, love it. This, by the way, is Ashley Benefield sitting right here, coming in and out to the courtroom from home. Okay, so there she is. We only see the back of her head, unfortunately, here.
State you got your own drinks.
Yes.
All right.
Thank you.
So the court's going to have to indulge me. But I want to read something from the state Supreme Court in Kathleen Weiland versus State of Florida. This is at 732 Southern 2nd, 1044, and it's a 1999 decision reversing the second DCA. And the issue that was involved was a conviction for second-degree murder, and whether or not there should be a duty to retreat in the home. And this was the Supreme Court addressing that. And one of the reasons, the overriding reason that they gave for refusing to do that was what they style as B, implications for victims of domestic violence. And this is what the Supreme Court had to say. And again, I appreciate the court's indulgence for the record.
Okay, Ellie B from Tennessee said no, she hired him. So she had a public defender. I remember that. But then she, you know, because she claimed that she was indigent. And then they did talk about, I thought I heard like, okay, that she hired him. But then he said she's still indigent. So how I don't know how that works. If she hired him, I don't know. I thought he was a public defender based on what was said in this hearing. But okay. Thank you, Ellie B from Tennessee.
Imposing a duty to retreat from the home may adversely impact victims of domestic violence. Although the state argues that nothing has changed in the intervening years since Bobbitt to require us to recede from that decision, to the contrary, much has changed in the public policy of this state, based on increased knowledge about the plight of domestic violence victims. It is now widely recognized that domestic violence, quote, attacks are often repeated over time, and escape from the home is rarely possible without the threat of great personal violence or death, unquote. Imposition of the duty to retreat on a battered woman who finds herself the target of a unilateral, unprovoked attack in her own home is inherently unfair. During repeated instances of past abuse, she has retreated only to be caught, dragged back inside, and severely beaten again. If she manages to escape, other hurdles confront her. Where will she go if she has no money, no transportation, and her children are left behind in the care of an enraged man? What the duty to retreat exception means to a battered woman is that as long as it is a stranger who attacks her in her home, she has a right to fight back and labors under no duty to retreat. If the attacker is her husband or live-in partner, however, she must retreat. Studies show that women who retreat from the residence when attacked by their co-occupant, spouse, or boyfriend may in fact increase the danger of harm to themselves due to the possibility of attack after separation. According to Dr. Lenore Walker, quote, the batterer would often rather kill or die himself than separate from the battered woman, unquote. Experts in the field explain that separation or retreat can be the most dangerous time in the relationship for the victims of domestic violence because, quote, violence increases dramatically when a woman leaves an abusive relationship, unquote. A leading expert in the field...
Taylor, I gotta stop you. You're gonna have to, you're reading and reading and reading.
Okay, let me pause before we hear the snark, right? Are we ready? Do you have your snarky pants on? Because the judge sure does. La me, or is that how we say it? Is it lame? Is it la me? I never know. La me? Lame? Okay, she wasn't a battered woman is what you say. You say, she lured him to her new location, pretended to reconcile with him and offed him. If she was so scared, why did she ask him to load her U-Haul? I mean, those are good questions. And also, what the defense, this is the defense attorney. What he's saying now, you know, is, by the way, she's going for the battered woman syndrome right here. Let me say that again. She's going for the battered woman syndrome defense. Okay, so that's why these comments are being made as well, which is odd based on she wasn't living with him. She was living with her mom. She ran off when she was pregnant and then had the baby there without telling him. And he's like, what the hell? So, yeah. Also, Angela said she's a tiny woman with the injuries, hospital records, not that we know of, but there are court documents and things where he, you know, he shot around into the ceiling during an argument, he threw a gun, he punched the dog, he threw a cat, things like that, but we don't know about other things, right? Becky B said, battered woman, there was no evidence of that. So this case can go a few ways. If it goes the way, if we find out that she was really just using this defense, what a complete disservice to actual victims of domestic violence. If this is a card that she's playing, if this is something that she's making up to try to win the case, that will absolutely infuriate many of us. Probably all of us, right? I would hope all of us. Let's hope that's what's not happening here. Maybe it's a little bit of everything happening in this case. Who knows? We'll have to wait to trial to hear what happened.
Please tell me how this relates to the state's request that I order your expert to provide a proffer before he can testify. Well, I'm not seeing the connection.
I think this, what the state is arguing, and this is the reason why I told the court's already ruled on this, what the state's arguing is that the expert should not be allowed to testify.
No, they're asking for a proffer ahead of time. That's it.
Yeah. But there is no provision for such.
And I'm ready to make a ruling when everybody is done.
I'm done.
But I just, if you want to keep going, that's fine, but I'm going to need to understand the relevance of the quotes that you're reading me from that Florida Supreme YN case to understand how that plays into your arguments against the state's request for a proffer. I'm not understanding.
It doesn't. It goes to the broader issue. If the court was reconsidering it, I did not know whether or not the expert should be allowed to testify. And it speaks to their perception of domestic violence and what should be authorized. But I hear the court.
All right. If we get to that bridge, I'll let you cross it.
All right.
Okay. I am searching for the right words. My level of confusion as to what both sides are doing and arguing is about pegged. Multiple times throughout multiple hearings, including on July 11th of 2024, Mr. Taylor and the defendant have emphatically stated this is not a battered spouse syndrome case. I've heard that multiple times, and I specifically pick the hearings we had on July 11th on other matters because it came up right at the end about the deposition of the expert. Mr. Ferris was coming up, and Ms. O'Donnell had said, I don't have a transcript, this is from my memory, Ms. O'Donnell had raised an objection that if Mr. Ferris was going to talk about, or he was a battered spouse syndrome expert, the required notice under the rule had not been given. And Mr. Taylor said again that this is not a battered spouse syndrome case. And so I left the courtroom on July 11th saying, okay, this is not a battered spouse syndrome case. We'll see what happens at the deposition. The very next day, on June 12th, at 4:33 p.m., the defense files notice of intent to rely upon battered spouse syndrome defense. And I looked at the notice of intent, and it complies with the rule. It gives the required notice. It talks about what evidence is going to be used to support the battered spouse syndrome defense. It provides the essential facts upon which the defense is going to rely. It provides a list of witnesses, including G. Bruce Eric Ferris, as witnesses who are going to support the battered spouse syndrome defense. And I don't recall if it was at that hearing or another hearing, we had a fairly in-depth discussion about the case law, including Oquendo and the differences between PTSD and reasonable person, and how battered spouse syndrome can be used in a stand your ground or a self-defense situation. But the emphasis was still, this is not a battered spouse case.
Judge, in fairness, I footnote.
That's why the judge is like, did we not already discuss that this would not be a battered spouse syndrome defense? And that's what it sounded like they discussed. But then the defense is like, okay, our defense will be battered spouse syndrome. The judge is like, I'm confused. Rob, thank you so much. You said, thank you for covering this case, G. Thank you so much for being here and watching this with me. And I look forward to watching the trial with you. So let's keep going here. This is just point 1. I've got 9 key moments. So I just want to listen for a little bit on this point, and then we're going to skip forward to the next point, okay?
Noted that.
In Hickson, I'm sorry, and so I'm confused there. On the state side, I've looked at the state's motion in limine to request a proffer of expert testimony. What I don't see in here is authority for that, where I can order the other side, you will give me a proffer of your witness's testimony for me to make a decision. I've made decisions based on a transcript that's been provided to me on discrete areas that may or may not be admissible. What this screams out to me, and I have no idea why we're not doing it, is a Daubert hearing. That certainly one side or the other can move for a pretrial ruling on the admissibility of scientific or technical evidence under 90.702 and the federal Daubert standard, where all of these issues, the qualifications of the expert, what they relied on, are those sources reliable? Did they apply reasonable and scientific methods? I mean, all the I don't have the predicate in front of me, but that's where that hearing would be. Ask for a Daubert hearing, the other side needs to comply. So I don't consider today a Daubert hearing. This is just a straight motion in limine where I haven't heard from the expert. I haven't heard anything, I don't have any facts in front of me about the Daubert factors or 90.702 factors. I haven't even been provided a copy of his transcript. So I don't know why we didn't do that. Next, my confusion is we discussed Hickson at a prior hearing, and it talks about as reflected in the rule, and I think, if I remember correctly, Hickson was a Florida Supreme Court decision that predated this rule and essentially laid out the framework of what eventually became Rule 3.201, I think it is, the battered spouse rule. And so Hickson kind of laid that out and fleshed out within the Rules Committee, turned into the actual rule that was then subsequently approved by the rulemaking process. And what Hickson talks about is, if it's a battered spouse case, and the rule as well, and the expert interviews the defendant, then the state has every right to get its own expert to do its own evaluation of the defendant. Now, what I've heard is apparently Mr. Ferris, during his interview, or during his deposition, said he interviewed the defendant for several, and I'm just relying on representations now, I have not seen it with my own eyes, interviewed the defendant for several hours. There was some initial veracity or some initial interview. I don't know how long that was, but then there were 2 subsequent interviews after he was retained for this case. On the flip side, if the expert does not evaluate the defendant and is going to just speak about general, non-specific traits, which is what I've been hearing for the defense, it's going to be very general, it's going to be very non-specific. There was talk from the defense about there's going to be hypotheticals posed, but I will say that in the back of my mind I was always wondering what those hypotheticals were going to be, if they were going to be very generic and non-specific, and then those hypotheticals started bringing in the facts of this case, how that would play out, but here nor there. That'll be a decision to be made later. But in this situation, what I'm hearing is the expert evaluated the defendant twice. And I only say this has nothing to do with my ruling on whether I'm going to order a proffer or not. It just goes to I want to just flesh out the issues of my confusion about, is this battered spouse, is it not? What part of Hickson are we talking about? Is there been an evaluation and there's going to be hypotheticals and opinions expressed based upon the facts of this case? Or is this just going to be a very generic, he hasn't interviewed her, it's going to be a very generic discussion about domestic violence victims? We all know what brackish water is. I don't think Hickson allows for some kind of brackish presentation here. It's either battered spouse syndrome and there was an evaluation and the state has a right to do its own expert evaluation, or there was no evaluation and it's purely generic information and hypotheticals. I say all of that with, just so you guys have the walking away knowledge of, we're less than a week from trial and I am so confused, is this a battered spouse syndrome case or not? I keep hearing it is, I keep hearing it isn't. I've heard everything I'm going to hear. I mean, I gave you both multiple opportunities to tell me. You just need to know, I still don't know where we're at. But my answer is this. I don't think there's any, I can't think of any provision under the law, I'm not aware of any authority under the rules that would allow me, and I haven't been provided any case law authority that gives me the discretion to say, defense, you will proffer your expert testimony. It's usually the opposite, right?
Just a quick pause. Welcome, everyone. We are watching some key moments from the pretrial hearing. The pretrial hearing took place yesterday on July 16th of 2024, and it was 5 hours and 7 minutes long. So we're not going to watch the whole 5 hours and 7 minutes. I have highlighted some key points for you in my notebook. We're now at 1 hour and 2 minutes of the defleft footage that I made. The total defleft is 4 hours and 7 minutes, but I'm going to link the full one for you in the description box. And the judge is Stephen White. The trial starts with jury selection, so the jury has not been selected yet. The jury selection will take place on the 22nd of July, and then they think it should be about a day, maybe 2 days to select the jury, and the trial is set to last for a week or two. So not the longest trial of all time either, but a very interesting case that we've been preparing for since 2023. In part 1, if you watch that, you'll hear me say, oh, and now the trial is coming up, so now we're preparing, and that took a whole nother year. In my description box, I had to update it because I said summer of 2023, we'll be watching the trial. It's like, damn, okay, summer of 2024, it is. All right, so if you watch part 1, don't get confused. The trial starts July 22nd of 2024, but please do watch part 1 because we did a deep dive on this case.
Somebody wants to put something in, I have an objection, I rule it's out, and the defense or the state will proffer it so it's in the record. And of course, that proffer is, if you read the appellate court decisions on that, this is why it's so important for the proponent to get that proffer in, because it gives the trial court that opportunity to hear the evidence and hear the questions and hear the cross and make a ruling that avoids trial court error. So, with that lengthy explanation, the state's request for the court to order the defendant to provide a, there it is, proffer is denied.
Okay, I'm going to now skip forward to 1 hour and 18 as I put in my notebook here. So just hold on. There we go. This is the defendant, Ashley Benefield. And on the top right-hand corner, you can see, because we only see the back of her head like this, there she is with Doug Benefield, who was her husband, who she shot on September 27th of 2020. She claims in self-defense. And that's what this whole case is about, you know. Was it self-defense or was it homicide? She's charged with second-degree murder. And on the left-hand side here, you could see Doug Benefield, the victim of this crime. Okay, so there we go. All right, so now we're skipping forward to 1 hour and 18 minutes out of my defleft pre-trial footage that we've got. So here we go. Let's listen to this a little bit.
Of matters that demonstrate bias are those that relate to the interests of the witness, favoritism, and corruption. So here's what we have in this case. And I know that the court didn't appreciate it. Bias against women is endemic to America's institutions.
Did you just say I didn't appreciate something?
I'm sorry?
Did you just say I didn't appreciate something?
Don't you love that? Don't you? This judge is like, did you just say that I did not appreciate something? He's like, sorry, what? The defense is still like, you know, getting that momentum for his argument here. Just like, listen, no, the court didn't appreciate it, but, and he's like, excuse me. So let's hear the snark.
I don't know if that's what I said.
Hold on, I'll tell us. I'll check. So here's what we have in this case, and I know the court didn't appreciate it. Bias against women is endemic to America's institution.
Yeah, I'm getting
so
ready.
What do I not appreciate?
I'm getting ready to tie in what the court didn't appreciate. I footnoted in my notice of battered spouse syndrome that it wasn't traditional battered spouse syndrome, because traditional is the woman is still in the home. In this case, she was not still in the home. All right? But bias against women is endemic to all our institutions. And what we have in the testimony of Justin Warren is my opportunity to show that that bias was at stake. And the court is prohibiting me from the granting of its motion in limine that the state filed from questioning Detective Warren.
I'm sorry, point out in my amended omnibus order where I said you may not do that?
You granted the state's motion and said that until such time as I show it is relevant.
So I didn't say no. I said any impeachment must be relevant and material.
Correct. And
okay.
I have filed this clarification to show the court that it is both relevant and material, and that's why I cited this case law. I don't want to be in a position, Your Honor, where my cross-examination throughout the trial is methodically interrupted by either an objection from the state or we have to send the jury in and out on multiple occasions, because that's going to create, it's not only going to render my examination less effective, it's going to create animus. I don't know if the jury's animus, I don't know where it's going to be directed. I only know that I'm here with an obligation to defend Ms. Benefield to the best of my ability. And under the case law, such a cross-examination of the lead detective is clearly relevant and material. So I have filed this clarification so that we could get past that. That's the purpose of this. I attached to my motion an excerpt from the deposition of Detective Justin Warren, wherein he says, all homicides are murders, and all who kill are murderers. Now, to me, Your Honor, that is clearly a bias. And it makes me wonder what chance Miss Benefield had in the mind of Detective Warren when he was already describing this as a murder less than 45 minutes after the shooting, when he was drawing up his first search warrant. That is indicative of bias. I am allowed to probe that detective on cross-examination to show that his decision was motivated by bias. Whether or not I'm successful is a separate collateral issue. That'll be up to the jury. But the court, nonetheless, provisionally granted the state's motion in limine. Again, I filed this clarification so that we could get past that, especially given the fact that self-defense is Ms. Benefield's defense. And if you have a lead detective saying that all homicides are murders, it's not only a complete misstatement of the law, but it clearly shows bias. According to him, the 90-year-old motorist who has a diabetic incident while he's driving his car and hits and kills a pedestrian is a murderer. And the fact of the matter is, under the law, that would be an excusable homicide, assuming no drugs or anything else was at play. The court is provisionally restricting me from questioning the detective about that. That shows bias. It's a fair inquiry on behalf of Ms. Benefield, and I should clearly be allowed to make that inquiry, and I think the court restricting me from doing it is an impermissible preclusion of Ms. Benefield's right of cross-examination.
Stefan says, I wonder if the judge appreciates that explanation. Well, let's see.
That's my position, Your Honor.
State?
Judge, I would just say this is not a motion to clarify. This is a motion to state everything I've already stated that the court has already ruled on, and I think your order is clear. Thank you.
Mr. Taylor, rebuttal?
No.
All right. After I reviewed the defendant's request for clarification of the court's amended omnibus order, I read it as a motion for rehearing. I reviewed it carefully to see if there was any legal points or factual points that weren't addressed or needed clarifying. I will note that the state had filed a motion for clarification, and as I reviewed my prior order, I did notice that I had neglected to put the actual legal ruling in and the basis for that. However, I've had a chance to review the amended omnibus order, and I don't think it needs clarification, and quite frankly, I find that the request for clarification is really a motion for rehearing, and I'm going to deny it.
Okay, so we've got that. Now we're going to skip forward to 1 hour 35 on here. Just hold on. 1:35. Find the spot here.
At June 21st of 2024, it's my understanding she was listed on July 12th, well past. My mind is just swimming with questions.
Okay. Judge, she was disclosed in the discovery that went out in 2021. Her initial reports, it's voluminous. It's in the discovery. What was omitted unintentionally was her name from the witness list. But the defense has had numerous reports of Kim Griffin. She is a coordinator at CPT, and she was involved in some of the previous allegations, the investigation of some of the previous allegations against Doug Benefield.
All right. So her reports went out.
Yes.
Related to some CPT or CPS investigation.
Yes.
But she wasn't listed.
Correct. Her name was not listed. It was an inadvertent mistake. I actually thought her name was listed all this time. I went back to look and realized that there was someone else named Kim, first name Kimberly or Kim, and that must have been why I thought she was listed. So I immediately, and this was on June 3rd, or when I spoke to Ms. Griffin in preparation for trial, she indicated to me that she had some typed notes. So I immediately gave those to the defense, and that was on the 3rd of July. Those notes were not in my possession until the 3rd of July, but they basically pretty much reiterate what's already in the documents that were already given over to the defense. Still at this point, I thought her name was on the witness list. It wasn't until I realized my mistake on the 12th that she was actually listed as a witness, on the witness list. So, yes, her name was listed late. She has been a part of this discovery. Her reports have been in discovery. It's not like she is a new, unexpected witness. I think everyone knew about her all along. and it was an inadvertent mistake that she was not.
But I wouldn't know, putting myself in the shoes of Mr. Taylor, how do I know, is she A, B, or C? So I get these reports, you don't list her, that tells me she doesn't have information related to this matter. You give me these reports, she's not listed as A, B, or C, telling me that, hey, she has information, and I can depose her, or no, she's off limits, I can't depose her.
And I would assume that the defense would not know, Judge. But the state is obligated to list every witness that is listed in discovery. So technically, every witness whose name shows up in discovery should be listed in discovery, and her name, by virtue of not being there, is an indication that there was a mistake, because it should have been in there to begin.
Or she's not relevant, she has no information related to the matter.
Okay. And that may be true. But
I'm just saying, if we're going to make assumptions, there's other assumptions that could fit that
Yes.
scenario.
Yes. As an aside, this witness is available for deposition and can be deposed this week. I just deposed Barbara Russell on Friday. So we are continuing discovery right up until trial. It's not unusual. While I wish this had not happened and I wish I had listed her name earlier, I think it is, there is a remedy, and that if the defense would like to depose her, I anticipate her testimony is only going to mirror what is in her reports. So it's no new information. She would not be testifying as an expert. The word expert is next to her name because in our system, typically when she is listed in child abuse cases, when she testifies in child abuse cases, she is an expert forensic interviewer.
Look at the judge's face now. It's like, yeah, he doesn't take any nonsense. So we're getting to our next point here. I'm just ticking off as we go. So we looked at 1, 2, 3. This is the fourth point coming up now out of 9 key moments in this pretrial hearing, okay?
So she's listed as an expert at the state attorney's office, but she did not conduct a forensic interview in this case. So her testimony would be non-expert testimony, pure factual, based on the information that came in and what transpired after that.
All right. So this is one of those situations where going from practitioner to judge becomes so pronounced. You guys have been living this case for almost 4 years now. So when you tell me it's in her notes, her testimony is going to mirror what's in her reports, that means something to you all. It means zero to me. What is she going to testify about? She's a fact witness. What does she know about the homicide that occurred on whatever day it was, September 27th of 2020? I mean, how is she relevant?
She will testify about the previous reports, how we had
There was a deputy that
Detective
testified.
Moreland testifying about the criminal aspect.
And I
of it.
limited what he could say.
Exactly. And her testimony would be similar, the child protection end of it, but also limited in what she can say. But that would be the information that she would testify about.
Is it the same incidents?
Yes.
Right, because it gets reported, 1-800-96 abuse, calls made, it gets routed to CPS or CPT. I still get confused about who's what and who's who.
Right.
Miss Glenn, I'm just going to do this for real quick and then we're going to take your plea.
Okay, thank you.
I'm not going to make you wait.
That's no problem.
Thank you.
I got time.
It gets routed there. It may just stay in I say DP world because the dependency cases, right? Maybe it just stays with CPS or MSO, their child protective team. Maybe there's also a criminal investigation, so it could open a CF or an MM case.
Right.
It could also turn into a DP, a dependency case. And then, of course, all of those things could then also be part of a DR case. Right. And we have some of that here.
Just a quick pause. Welcome, everyone. Thank you for being here. This is part 2 of the trial prep for the Ashley Benefield trial starting on July 22nd of 2024 with jury selection. And then it should last a day, or maybe 2. They said about a day during this pretrial hearing. And then the trial is set to last a week or 2. The only witness for the defense is Ashley Benefield, the defendant's mother. That's going to be interesting in itself. I wonder how long she'll be on the stand, right? And she just backs up, of course, all of her daughter's claims. So maybe it's true, maybe it's not. I don't know. Sophia said, it seems like the judge is allergic to BS. I hope I'm not too soft compared to the footage. Sorry about that. Also, KLF says, have you seen Ashley's supporters' website? Obviously not objective, but it's interesting. We're going to be looking at that in part 3, which will be tomorrow. We're going to look at the other side of the story, right? We're going to look at Ashley's side of the story a little bit more in depth. We're going to see a letter that she wrote to her husband when she had left to go and live with her mom. We're going to be looking at her supporters' website. And by supporters, I mean they're rallying, like you saw, protesting outside, like kind of a little bit like the Karen retrial, you know? Lots of supporters, all wearing purple, saying victims of domestic violence should be able to protect themselves and self-defense isn't murder and all that. The biggest concern that people have with this case is, was it really self-defense, you know? And one doesn't want to question if someone is she really a victim of domestic violence? But in this case, we looked at a lot of red flags in part 1 already and in today's presentation at the beginning of the stream. So if you missed it, check it out. I'll make sure to put timestamps in for you. There's a couple of red flags here that you're like, is it possible that this defendant could be twisting the narrative to suit her? Do you know what I mean? Ooh, I don't know. We'll have to see. We'll have to see what all they present at the trial. And I think it's going to be very interesting, right? So yes, Pernille said yes with a delay. We will be doing a delayed trial coverage just by a few hours so that we can defluff, meaning skip over the coffee breaks and the lunch breaks and all that stuff, right? Okay, so let's keep going here. We're now at, we've got another few minutes here, and then we're going to skip to the next timestamp that I've made for you.
I guess my question is, I think I already made the ruling over the defendant's objection that I would allow Detective Moreland to testify at the trial, essentially what I allowed at the stand your ground hearing.
Yes.
And now you're saying, and we want another person to come in and testify about those exact same things.
Judge, it's from a different angle. It is from the child protection team angle, and as Your Honor just said, they're two very different, they have different goals, they have different jobs, and so I think it's important that the same thing happened in two different agencies that have different goals. The detective is talking solely about criminal charges. CPT and CPS is speaking specifically about DR cases or, dependency cases. So it's for two very different reasons that they're each doing evaluations. And the fact that neither law enforcement nor the family realm proceeded with charges or cases. I think it's important to differentiate between the criminal world and the family world, and that is two different sectors, and that they could do two different things, and neither one of them did.
But I still never got this clear answer. There was a DP case. Was there?
Pause. Okay, so police 123 CD said, if I heard correctly that she shot him in the back, how is she claiming self-defense? So we haven't seen evidence of that, but investigators say that it doesn't, based on the evidence, based on where you were shot and how you were shot, and where, because she shot 4 rounds, right? She missed twice. Based on that, they don't think that Doug, the victim, was even facing her when she started shooting. That he wasn't like attacking her and then she shot. It seemed like he was looking in the closet for maybe that final box that was going to go in the U-Haul, and then she shot him. It seems like that is what they're saying, okay? That's based on the probable cause affidavit and all these other documents we've looked at before. If you want to read through the probable cause affidavit with me, it's in part 1, which is in the description box on the community tab. It's on the playlist that you can find called Black Swan Trial on my channel, okay? So actually now I'm going to just skip forward here to 1 hour 50 because they talk about this for a little bit. So let's go here.
And that would not be the intent of the state. It would be to address it as though they were 4 calls, and this is what law enforcement did, and this is what the CPT, CPS side of it did. And in neither one did the defendant get the satisfaction that she was looking for, either because, and I do not believe it's cumulative because it's two different aspects. It's criminal and family, and neither the family realm nor the criminal realm gave the defendant what she was seeking. And I think it's fair for the state to put on each of those realms to say, yes, we investigated, we did what we normally do, and we did not go forward.
All right. Thank you, ma'am. Was that everything?
Yes.
I didn't want to cut you off. All right, Mr. Taylor.
Now, I want to start off by telling Your Honor, CPT does not conduct investigations, period. They are not investigators. For Kimberly Griffin to be described as an investigator is not correct. She may have been a manager. She is not an investigator. CPT does not conduct investigations. That's number one. Number two, the court may recall, I mentioned earlier that the state's theory initially, as long as Judge Moreland's pronouncement was admissible, was that created the motivation for Miss Benefield to kill her husband because she knew that Dr. Broder's report was to be released 3 days later. Now, the courts prohibited the state from using Judge Moreland's pronouncement. So they have pivoted, and now what they're going to do is they're going to say that failure to receive satisfaction from any of these child abuse allegations created the motivation for Miss Benefield to shoot Douglas Benefield. Well, here's the problems that they have with this. And here's instinctively where I believe the court is having problems reconciling it. First of all, the court ruled as to Deputy Moreland that he would be limited, no different than the court ruled as to the domestic violence injunction that Judge Moreland denied. Deputy Moreland would be able to say they received the complaint, no action was taken, the end. No comments one way or the other. Well, the problem with this is, by implication, if not by actual design, they want to disclose to the jurors that the person making the report, the allegation, is Ashley Benefield. If nothing else, the court has got to realize from the law that we provided, Your Honor, they cannot disclose.
Before you go much further, I'm pretty sure they put in writing that they're not going to argue that or present that testimony or evidence.
Right.
Okay. I think they put that in writing.
Okay. Then what could the relevance of this possibly be? What is Kimberly Griffin, who is disclosed at the last minute, going to add that Deputy Moreland is not going to present? I think
It's quite hectic, right? Heather says, Heather, whatever. You say, talking down to the judge? This guy's a gambler. It's it's pretty risky, right? I mean, this is at the pre-trial hearing. How's the trial gonna be? Oh, my word.
the implication is because she's from CPT, it raises the issue of child abuse and whether or not allegations made were vindicated. We got enough to do in this case dealing with the charge of second-degree murder. The trial's not supposed to be about whether or not the allegations of abuse were founded or unfounded, true or false. And I think under 403, it very well may create in the minds of the jurors, well, let's see, okay, the deputy came in and said there had been some matters investigated, but nothing came of it. Well, why is child protection here? What is that all about? Was there something going on that we don't know about? I think it's an opportunity for contamination of the trial with nothing really to be gained.
Which is kind of weird. If I were her defense attorney, wouldn't that kind of be in her favor if juries were like, whoa, if CPS was involved, is that why? Like, if she thought he could harm their daughter, whoa, and then there's all these allegations of abusing her. Okay, you know what I mean? Wouldn't that be in her favor? But this defense attorney's like, we want that out.
He's not going to add anything of significance, hence the court's evaluation under 403. What's the probative value? There is no relevance to it. It adds absolutely nothing to what Deputy Moreland is going to say. Additionally,
Pause, Phoebe. The little girl is, Phoebe's asking how old is the child now? Apparently 6 years old now. And at the beginning of this stream, I showed you a little clip of that Court TV had put up because their reporters were outside the courtroom. And Ashley Benefield, the defendant, has her daughter standing outside there with a poster saying, "Keep my mommy free." That is so manipulative and so not protective of her daughter, and I think it's abusive. to her child. So that doesn't do her any favors. You know, putting her child there and saying, like, keep my mommy free, pleading with all, you know, all the fans of Ashley Benefield. I don't like it. Let me know. Let me know what you think, right? Carla Lilly said he actually works for the state. He was a former prosecutor, right? This guy. Okay.
I mean, look, Judge, I attached it even to my response on the last page. It couldn't be any clearer. This is from the report from CPT. Confidential dissemination of this material is restricted under Florida Statute Section 39.2026. This is precluded from being presented to a jury.
Well, we need to kind of step past that. I mean, you've been doing criminal defense long enough. I assume, were you with the state in the past?
Have I what?
Have you been with the state in the past? Have you done both sides? Were you a prosecutor at any point?
Yes, state and federal.
All right. CPT videos are introduced into evidence in child sex cases. The interviews with the minor victims are put into evidence all the time, and the records can come in. So there are exceptions for records to be admitted into other criminal proceedings.
I was just going to say to the court, you're absolutely right, and that exception was added to the statute several years ago. There is no exception for this. If the court looks at the statute, there is no exception to call some CPT case manager to disclose things that are not entitled to be disseminated. And even if there was, what is the probative value? What is it going to add that Deputy Moreland is not going to provide? Further, it raises the issue and puts me in the position that, and the court knows how testimony is, if something comes out, we have two complaints that were filed in this case by independent third parties, both professionals, one a pediatrician and the other a psychologist. Independently, they called in child abuse complaints to DCF or CPT. If I get a statement by this witness that's adverse to Ms. Benefield, I have to go there. That's going to open up a can of worms, once again, that's going to jeopardize the jury's consideration of what's at play here. And why are we doing it? What is the probative value that puts us in the position to risk that? There is none. And even if the court gets past what a late disclosure this was, even though they've now withdrawn her as an expert, it's still inappropriate. It was late. I'm 5 days out from trial. I don't have the time to chase a deposition now, and it adds nothing, and I think the court should deny it.
This defense attorney is very snarky too, huh? It's going to be quite a trial. Let me show you quickly the clip that I'm referring to, where that's Ashley Benefield's daughter standing with Ashley Benefield's mother, so the little girl's grandmother, saying, "Keep my mommy free." Look at that, outside the courtroom. I don't like that. I don't think that's necessary at all, and it's not good for the child at all. I mean, it is her dad that was shot by her mom, so to say, keep my mommy, I don't know, man. It's just, this is not okay, in my opinion. Let me know what you think. Okay, so that's the clip that we're all talking about that I showed at the beginning of the stream. Now let's keep going here.
Let me ask you this. As you've noticed with several of my rulings over the last couple of months, I hesitate to make a pretrial ruling that tells either party, you may not call this witness. I think I've demonstrated that.
Yes.
With the understanding that I've already made the ruling, detective or deputy, whatever his name is, Moreland can, now I can't say Moreland because then we're going to confuse the other way. I'm just going to say Detective Moreland, that's how I remember it. With the knowledge that I've allowed already that Detective Moreland can testify to these 4 complaints, criminal matters that came to his division, when the essential allegations, they were investigated, closed with no charges being filed. Because again, I don't want to limit myself, but I seem to think that that's the ruling. If the state was allowed to elicit from Detective Moreland that those same complaints were also sent to the Child Protective Team. They conducted their separate investigation, and nothing was, I don't know, was anything filed? See, that's where I'm going to run into a problem, because there was a dependency case. I don't know which ones, I don't know which of these four, or was it some other investigation that led to the filing of the dependency case?
Well, let me remind the court of something. We objected to Deputy Moreland's testimony, and the basis for Your Honor's conclusion that it was admissible, at least the dichotomy that the court seemed to draw on, was that as a deputy, as part of a criminal inquiry, the court was going to allow it. Okay, we disagree, but we'll live with it. Now, though, we're over on the other side, completely away from that justification, and we're into the workings of CPT and what the implications of it are. And I'm only telling the court, particularly because there were two independent professionals who called in complaints.
Of the four that we're talking about?
I don't know if that was included in the four or not, but I'm telling the court that the pediatricians called in, as did one of the psychologists. I'm going to have to go there. And as soon as I go there, it's going to leave them wondering. And I'm just saying to the court, what is the prize that is allowing the court to consider taking that step and letting us go down that road? What is to be gained by Kimberly Griffin coming in and essentially, from the court's own questioning of Ms. O'Donnell, saying what the deputy had to say? What's the point? And I think it just opens us up to a problem with nothing to be gained. And I think that's overlooking and getting past the untimely discovery. So,
Which is that's still on the table.
yeah.
I didn't want to cut you off.
Right, and not to mention the confidentiality of this information. I mean, I put it in my response. It's pretty clear, Judge.
Mr. Donald, I do have to come back to you, though, because as I was thinking about, the excluding a witness, I think we can all agree the case law is very clear. The exclusion of a witness is one of the most extreme sanctions or decisions that a trial court can make when it comes to the time leading up to a trial. And the appellate courts have very clearly spelled out that that should be the very last option after looking at and considering and trying every other reasonable option that's available. So that's where I started thinking, and I'm just going to lay it out here so we have this discussion so we can try and get this done. Well, what if I allowed the state to bring in through Detective Moreland that along with his criminal investigation, that initial report goes two different places. There's criminal investigation, there's CPS or CPT investigation, and he investigated his end, it was closed, and Detective, just tell us briefly what the CPT is. I'm sure he could give a very generic overview of what they are and how, even though they're both in the sheriff's office, they are siloed in different departments. You just have him say, my cases were closed with no charges, but then I started thinking, well, some of these may have been the complaints that resulted in the dependency cases, and so it wouldn't fit.
I just don't want to miss this comment here. Noreen said, if I was the prosecution, I'd be having a word with the judge about her allowing her child to stand right outside the court. Not good. Potential jurors seeing that it's emotional blackmail. I mean, it's child abuse in plain sight and emotional blackmail, saying, please keep my mommy free. And even the defense has said at some point in this pre-trial hearing, she's got a 6-year-old child and she's facing 25 to life. Okay, we're not here to feel sorry for her. We want to hear the facts, right? And the jury's going to decide. I'm very eager to hear everything that they're going to present in this trial, that we're going to be watching together and having interesting conversations as it goes.
So how did you plan on addressing that with First, were any of the cases, the 4, I assume, cases Ms. Griffin was going to talk about, did any of those lead to the dependency case?
I'm not aware of that. And I apologize, Judge, because I've never done family court, so I'm not aware. I don't know what the difference is between dependency and domestic relations. They had a dissolution of marriage and issue of time sharing with the child pending for most of this, so I don't know if that qualifies as a dependency case.
That's a DR case. That's a domestic relations.
Okay, so that's what was pending. It wasn't dependency until, it's my understanding, until after the homicide happened, then it became a dependency case.
Oh.
So I think it was just, and you can correct me if I'm wrong, but I believe that it was all DR, domestic, related with marriage and time sharing and that type of thing, and criminal.
Okay. I don't know the words to express.
But so far, aren't you excited for this trial? You know, the way that everything's going, just the vibe of the court. I think it's going to be very interesting. The judge, I mean, very strong judge, very logical, but, you know, he doesn't take any nonsense or anything like that. Barbara said that's freedom of speech, having the daughter outside of court. I don't see it that way. I see it as child abuse and completely inappropriate. So she's not an adult, you know what I mean? She shouldn't be there. This is a case where her mother shot her father. She should not be there at all. So, okay, let's keep going here. I'm just very disturbed by that child standing outside there. That's probably going to be addressed at some point in the courtroom or before the trial or something like that. I'm sure the judge will be made aware of it, right? Okay, so now we're gonna skip forward to 2 hours and 17 over here. As I say, if you want to see the entire pretrial hearing, I'm going to link it for you in the description box.
I'm not detective. Ms. Griffin's testimony to just the essential allegations as I allowed Detective Moreland. And I could certainly require either a limiting instruction or require testimony to be clear that Ms. Griffin and Detective Moreland are referencing the same complaints. And they may have to check that because I don't know yet. I haven't received competent substantial evidence that they were the same 4 complaints. But I'm going to operate on the presumption that they were. The reason Detective Moreland's testimony works is it's relevant to the state's position, and I'm able to avoid problems with 403 by limiting what he's allowed to testify to. My concern with Ms. Griffin, as I expressed earlier, is the fact that it appears that one or more of those phone calls that Detective Moreland is going to say didn't result in criminal charges, on the CPT side of it, resulted in some sort of action, whether we're going to call it a dependency case, they opened that but it just wasn't filed, whether it was called a staffing, whatever it was called. I haven't received testimony or evidence what they call it, but some sort of action by the Child Protective Team to address those allegations, because we've got meetings with CPT, we've got these interviews that I've heard about, we've got Dr. Broder being brought in. From the testimony I remember at the Stand Your Ground hearing, he seemed to have been involved for several months, meeting with everybody multiple times, hours and hours of observation time and interview time with the parties. And my concern is Ms. Griffin's testimony is going to be, yes, as CPT, we did these investigations, and we felt there was enough for us to get Dr. Broder involved and at least take some sort of agency action. And to the extent that I said earlier, I think that could confuse the issues, and at that point the probative value is substantially outweighed by the danger of confusion of the issues to the jury, and misleading of the jury as to how many complaints were actually made. But I don't disagree with the defense, is that if then Ms. Griffin is allowed to testify that based upon these complaints, yes, we did take some action, and Dr. Broder was brought in, and we did these, whatever it's called in their nomenclature. I'm just going to call it a staffing. Yeah, I think basically what I'm asking for there and what I'm going to allow or have to allow for the defendant to fully address those issues is we're going to have a mini dependency trial within this murder trial. And if my rulings before haven't been clear, at least implicitly clear, this is a homicide trial, a murder trial. I'm trying to avoid having a family law, domestic relations, divorce, child custody, child time sharing trial within this murder trial. I'm trying to avoid having a criminal trial of other criminal charges that may or may not be appropriate in this murder trial. I'm trying to avoid having a dependency case in this trial, within a trial, just to keep everybody focused on the issues. And I've tried to give latitude to both sides to follow their theories and present their defenses and their arguments on the state side, but the nets that both sides are casting are just getting a little bit too wide. So based upon that,
Judge, can I just clarify something real quickly? I wasn't sure. I know that you said that the CPT did recommend a staffing. The staffing was basically to evaluate why the defendant kept making allegations. It wasn't against.
I don't know that.
Okay. Well, the way you said it made it sound like it was against maybe Doug Benefield. I don't know. I don't know if that makes a difference.
I have. That's what I'm trying to say is I have zero idea.
Okay.
What was it for? Did they put some credence in some of these complaints? Did they finally realize that this is a repeated false allegations we need to get? I don't know. I have zero idea.
That was why.
All right. So at this point, and this is just a motion in limine, but based upon what I've heard so far, no, I would not allow Ms. Griffin to testify on the 403 grounds. I think it's just going to, the probative value is substantially outweighed by the danger of confusion of the issues, misleading of the jury. So I am going to, I don't even know what I'm granting.
Just a quick pause there. Liana, thank you so much for your sticker from South Africa. You say it's very important to look at all sides. We live in a he said, she said world. Everything is not always black and white, unfortunately. Absolutely, and I'm hoping we're going to, Doug is not here to defend himself. He was murdered, but I'm hoping we're going to hear all the evidence from, obviously both sides and be able to make up our own minds about this. This is up to the jury. It's not up to us, as we all know. So we are entitled to our opinions, but at this point, there's a lot of red flags everywhere, right? And yeah, Ashley does seem like a master manipulator. But is there any merit to what she was saying? Did she feel like, her life was in danger? I don't know. We'll have to see what this trial presents, which is why I'm excited to watch it with you. Like, whoa, this is interesting. It's not the usual, DV case we see, right? Lariah, thank you for being a member for 1 month. You said this is my favorite cave to hibernate in. Welcome to it. And also happy birthday to Debbie McCarthy. Thank you for spending time here with us on your birthday.
I'm going to grant the defense's motion in limine to prevent Ms. Griffin from testifying. That obviates the need, obviously, for a Daubert, because the state had already said they weren't an expert. She wasn't an expert.
Okay, so again, if you want to hear the full pretrial hearing, I'll link the full thing for you in the description box. I'm going to skip forward now to 3 hours 34 over here. I'm just giving you some highlights, right? We're just getting a taste for the courtroom, how the trial's going to be, and hearing some important moments from the pretrial hearing.
Yes.
Part of my voir dire revolves around the presumption of innocence and presenting to the jurors a scenario upon which to draw the application of the presumption of innocence. Understanding that, then, I will ask them. So if, for example, you were to be told, okay, you have to reach your verdict now, what would your verdict be? And surprisingly, way too often, they don't understand, and the response is, well, we haven't heard any testimony. Is the court saying that that's prohibited?
Do I have good news for you? My voir dire portion takes about an hour and 15 minutes.
Okay.
You know, some judges do very little, and some judges do quite a bit. I am fairly active. When we actually get to that point, I discuss three very important legal concepts with the jury, which they've probably heard, and I'm sort of paraphrasing from what I read, which they've probably heard many times before on television or in the movies or in the news. Those three concepts are the right to remain silent, the presumption of innocence, and the burden of proof. Under the presumption of innocence, I will say, oftentimes I hear panels such as yours asked during jury selection, if you were sent back to the jury room right now, before any evidence is presented, what would your verdict be? The answer is invariably, I couldn't find the defendant guilty or not guilty because I've not heard or seen any evidence. Judge, you just told me that. And I say, however, because our laws are clear on the presumption of innocence, the answer in that situation is that you would have to find the defendant not guilty, because the state has not presented any evidence, and the presumption of innocence compels a finding of not guilty. And I ask them, does everybody understand this presumption of innocence? Does everyone agree with this presumption of innocence applying to Miss Benefield?
And what about, Your Honor, if they go back into the jury room for deliberations and they're not sure about what happened? That they have some questions indicative of the state not meeting its burden of proof beyond a reasonable doubt. Does the court... You know, one of the things that I have found, Judge, it's rare that the jurors are going to acknowledge anything other than a nod of their head in response to the court telling them, okay, this is the presumption of innocence. But it's quite another thing for the lawyer when he's up there to ask them, have they ever seen a police car by the side of the road with somebody in the back seat? What's the first thing you thought? And the hands will go up and they'll say, gee, I wonder what they did. And of course, that, in contrast to the presumption of innocence, is completely inconsistent.
I've allowed that.
Like, I know the defense is there to defend his client, right? We know that. You've got to do that. But it just feels a little bit like he's trying to control everything about the trial, how everything's going to work, like what is the jury going to think at what point and what's going to happen, right? Doesn't it feel like that a little bit? Pia Storm, welcome to Grizzly Supporter. Thank you so much for becoming a member. Welcome to all the members. If you're only joining today or you recently joined, please check out the members only playlist. I'm sure there's lots that you can watch over there. Lots of snark tank material and general light conversations. Okay, and a little bit behind the scenes type of conversations too, if you want to see that. So Eva, Doug Benefield's biological daughter from his first marriage, I think she's 22 now. Okay, because this has taken 4 years to get to trial, and I think she was 18 at the time when it happened. So I think she's 21 or 22 now. I do think that she'll be testifying for the state. I'll have a look again at this. Yeah, she is listed there as the state's witness list. She is on it. Eva Benefield. That is going to be epic to see her. If you don't know who I'm talking about, as I say, it's Doug Benefield's biological daughter from his first marriage. His first wife died from a heart condition, and 9 months later, and only after 13 days of meeting her, he married Ashley Benefield. So, if you don't know the backstory and you want to see a little bit of Eva telling the story of, about Ashley and, just her side of things, then check out part 1, which is linked in the description box for you. It's on the playlist. It's on the community tab. It's all over the place. All right. So, okay, let's keep going here a little bit.
When somebody has wanted to use that particular one.
We don't have too much to go, okay, today.
if it stops there and just talks about the presumption of innocence is that
Yes.
the person hasn't done anything until it's been proven. If it's along those lines, I've allowed that one in the past.
So I will try not to repeat unless I think it's something significant, and if it's inappropriate.
And what you're talking about when they can't reach a verdict, I think that one I've seen asked, and how you're probably intending to do it is, if you're a lone holdout, are you going to give in, or are you the kind of person that's, going to advocate for your beliefs?
Well, I asked that also. That's just not being intimidated by the majority. But my concern in this case, Judge White, the presumption of innocence is basically a requirement that they say, I am prepared to start this trial believing that the shooting was justified. Now, state, prove to me beyond a reasonable doubt that it was not. Because that's what the trial is about. Ultimately, it's self-defense and was the shooting justified, and that's the instruction the court's going to give. So I would like to be able, within reason, to explain that to them and to present that to them as part of the presumption of innocence and the burden being on the state.
All I can say is this. If you're going to use a hypothetical, I want to hear about it ahead of time. Now, you may have used hypotheticals perfectly, and it always goes off without a hitch. That is not my experience. My experience with hypotheticals is it misleads and confuses the jury, and that it is oftentimes not a good analogy to try and get a point across, versus just saying, this is the law, will you follow it? That is, just be direct.
All right, well...
I like that, He's not going to just be like, okay, well, as long as it's just a hypothetical. He's like, well, in my experience, it's pretty misleading to the jury. It can confuse things and all of that. So, also, if you guys are new here and you've never heard of this case, please check out part 1, because there we did an entire deep dive presentation. We read the probable cause affidavit, and we heard Eva's side of the story, which is Doug Benefield's biological daughter, and she is awesome. So if you haven't seen her clips and she made like a 6-part series on TikTok telling her side of the story. Please go check out part 1 because it's on there. I've linked her TikTok account in my description box here and in part 1 and on the playlist as well. So if you get lost, just look in the description box, just click more and you'll find it there.
I will try to be as clear as I can. I generally don't give hypotheticals, but I would present the justification issue like I just suggested, so that they appreciate and understand this isn't really a murder case. I mean, we're not going to dispute that he...
But that's his defense. If he's like, this isn't really a murder case, well, the state believes it is. Many people believe it is a murder case. You know what I mean? So if that's the defense's strategy, to bring in a hypothetical, I don't know. I just like how the judge is like, yeah, no, I'm not going to allow that. Yes, I'll allow that. Nope, not that. Is really great, right? Ellen, how do I say your name? Ellen? Hologram. So it's so sad. Wonder what we can do to support Eva. If you watch part 1, it's all timestamped for you. Towards the end, we actually looked at a business that she started and that you could buy t-shirts that she designs. And that is one way to support her. And I've linked her website and everything in the description box of part 1.
Shot and killed. The issue was the force used justifiable?
Correct.
All right.
All right, jury instructions. I'm thinking back. I know I looked through the jury instructions that the defense handed up. Was that just the self-defense, or was it the entire set? I think I just asked for the self-defense instruction.
You asked for self-defense, and we included in that self-defense all of the statutes we felt the court obligated to try.
Right. So usually how the state does it is they prepare the standard jury instructions. So, Ms. Benefield, what you need to make sure you speak with your attorneys about regarding jury instructions, and sometimes people think of jury instructions as an afterthought, okay? Well, and especially as lawyers, like, of course we know the law. We've dealt with this. How many homicides have you defended or prosecuted over here? But the jury instructions are important because here's what the jury does. The jury is going to sit in the jury box and listen. They're going to listen to the testimony. They're going to see the exhibits. That's evidence, right? And then I'm going to instruct them on the law. That's the jury instructions, where the court says, this is the law in the state of Florida. They're going to hear the arguments of the attorneys, and they need to take all of that. They need to apply the law, the facts that they find have been proven beyond a reasonable doubt, and making determinations of credibility, and apply that to the law, and render a fair and impartial verdict. So jury instructions are incredibly important. Make sure you take time and speak with your attorney about that. I'm sure you have, but I'm saying it for the record as well, to make sure you spend time on that. What you're going to see is the murder in the second degree with a firearm has two different kinds of what we call lesser included offenses. And what I will instruct the jury is there's an instruction, you may have seen it already, and it essentially says, members of the jury, even if you think the state has not proven the main crime with which the defendant is charged has been proven beyond a reasonable doubt, there may be lesser included crimes that have been proven beyond a reasonable doubt. The lesser included crimes encompassed by the charge of murder in the second degree with a firearm, I'm pretty sure it's just manslaughter, isn't it?
Yes.
The manslaughter by act.
Yeah.
So what you're going to see on that list is Category 1 and Category 2. Category 1 lesser includeds are what we call mandatory, and they are supposed to be given in every case in which that main charge is tried. There's times when it isn't, but it's fairly rare. So that'll be Category 1 will be manslaughter. However, if you look at the second column, it's Category 2, which we also call permissive lesser included offenses. What that means is if in the charging document certain facts are alleged that would support the elements of one of those Category 2 lessers, and there's been sufficient evidence presented at trial to support that lesser included, then maybe you could ask for those. So talk with your attorney. There are pluses and minuses, benefits and drawbacks for asking for lesser includeds when they fit within the information and with the facts. Sometimes the strategy may be, hey, this is all or nothing. We only want the murder in the second degree and the mandatory manslaughter. We want no lesser includeds. It's all or nothing. And sometimes the decision may be, well, we want to give the jury some options. Maybe we'll argue that I'm not guilty of this and this, but maybe concede something lesser to give them something if they want to fall back on. That will be completely up to you and your attorneys whether you ask for those Category 2 lesser includeds or not. Does that all make sense?
I believe so.
Does Your Honor give any preliminary statement?
Oh, she did a bit of vocal fry. I believe so. That's all we heard. She hardly speaks at all.
About lesser included?
We're almost at our next point. We've got two more little key moments that I've made for you.
To the jury before the trial commences. Because we would request that the court not do.
No, I don't, unless I read 2.1, the standard preliminary, that with a few very minor edits. But no, I don't think anywhere in there does it talk about lesser includeds. No.
We have some case law that when the time comes to discuss the jury charge, that we feel is an all or nothing.
And we're going to move forward now to 3 hours 50.
You are laying your predicate because they're going to have the, and I'm pointing at the state because it's typically, how it works, because they have the right, as you're laying that predicate, to say, hey, this is not material. Hey, the answer that was given here, where they're going to try and impeach with a prior inconsistent statement, is not truly inconsistent. Hey, the witness said, I don't know, or I don't recall, which this is not a prior inconsistent statement under the law. So, just give an indication of where you're going to be impeaching from. And then opening. How much time do you think you need for opening?
Usually about a half an hour at the most, but.
Mr. Taylor?
That's fine, Your Honor.
All right. I don't think that is unreasonable, given the facts of this case. All right, Ms. Benefield.
It's not bad, right? They're like about half an hour at the most. Oh, for opening statements. I mean, we've seen longer ones, right?
As we know, I've placed you under oath. I do want to ask, and I'll have to ask some of these questions again Monday, just to make sure, but are you presently under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Are you taking any prescribed medications?
No, Your Honor.
Are there any prescription medications that you have that you are not taking?
No, Your Honor.
Are you presently suffering from any mental health issues?
No, Your Honor.
Have you been treated in the past for any mental health issues?
And then she's completely quiet. That was interesting.
I think the facts of this case establish that pretty clearly.
These are competency questions. I'm not going to start going into detail. I just want to make sure that she's competent to make a...
I can assure the court Ms. Benefield is competent. I have no reason to question it.
All right, let me ask this next question. Do you feel that your mind is clear and you're able to understand why we're here today and what we're doing?
I believe so, Your Honor.
All right. Has anybody forced you, threatened you, or coerced you to take this case to trial?
No, Your Honor.
Has anybody made any promises or guarantees to you by anyone to get you to take this to trial? That is, has anybody promised you anything about the jury's verdict, the sentence that could be imposed, any benefits, any drawbacks? Has anybody made you any promises or guarantees in any way, shape, or form about this case or the outcome of this case to get you to take it to trial?
No, Your Honor.
I've gone over the charge that you're facing, murder in the second degree with a firearm. Now, the next series of questions, I don't want to know anything about the specifics about what you've talked about with Mr. Taylor or any other of the legal professionals you've been dealing with. These are just confirming you've had these opportunities. Have you had the chance to discuss your case and the charge with your attorney?
Yes, Your Honor.
And has he answered all of the questions you've asked about the charge you're facing and the case, the state's case against you?
I believe so, Your Honor.
And you wanted to take your case to trial?
I suppose so, Your Honor.
There's no severance or bifurcation. Have you reviewed your criminal punishment code score sheet? Have you seen that yet?
She has not. She has not.
Okay. Do you have a copy?
I do not, Judge. I don't think that I've done one, but it would be at the bottom of the guidelines somewhere around 21 years.
And I might remind Your Honor that at a previous hearing, the court advised her as to the exposure that she has.
All right. And that's what this is to get to. Ultimately, if we get further down the road, there's any objections to the criminal punishment code score sheet, just let me know. All right. So I don't know the total sentence points at the bottom of the guidelines yet. But we have discussed, and Ms. Benefield, I'm sure you understand that if you are convicted of this offense as charged, the court would have no discretion but to sentence you to a minimum mandatory of 25 years, and it could be up to life.
I'm sorry, Your Honor. This was covered previously, and I think to go back over it again now is intimidating to my client.
Oh, I'm certainly not.
Listen, Judge, saying that she's going to face 25 to life, you're intimidating her now. Intimidating.
Not intending that at all. Ma'am, do you understand the maximum penalty you face? I'll just leave it at that.
Yes, Your Honor.
You understand minimum mandatories?
Yes, Your Honor.
Okay. State, have you received any offers from the defense to resolve this matter?
No.
Have you made any plea offers?
No.
All right. Ms. Benefield, if there's any plea offers that you want your attorney to make to the state, please do that as soon as possible. You do have three options. Did I go over the three options? Trial, open plea, or I don't recall going over it. So let me just mention, ma'am, you do have three main options whenever you're in a situation such as this. One is you can try and work out a plea agreement with the state. That would be where you and your attorney negotiate with the state to try and come up with an agreeable resolution. Your other option is to plea straight up or open to the court. Some people say throw yourself on the mercy of the court. And then, of course, a trial, and that could be a jury trial or a bench trial. And at this point, we are set to select a jury on Monday in this case. All right, ma'am, so you've had a chance to discuss the case with your attorney. Have you reviewed all the discovery that we talked about? Is there anything that's surprising that you haven't heard about? Have you reviewed everything that you have, Mr. Taylor, with her?
I can tell the court we have kept our client advised as to all of the evidence and discuss the case with her. I'm a little concerned some of these questions are intruding on the attorney-client relationship.
If you object to them, that's just fine. My intent is to make sure that the defendant is freely, intelligently, voluntarily taking this case to trial. And they understand, because, in 3850s, they come back and they say, I didn't know I could get life in this case. Nobody ever told me I faced a minimum mandatory. Nobody ever told me that the state was scoring death points. Nobody ever, wait a minute, I told my attorney to communicate this plea offer. What do you mean, state? You never heard of it. And this obviates all of those concerns.
I understand, but like I said, Your Honor has already advised her as to the penalties.
All right.
Don't say it again, Your Honor. It's just too traumatizing for her to know that she could face 25 to life if convicted. I mean, oh dear.
Is there any discovery outstanding, Mr. Taylor, that would require a motion to compel?
No, sir.
All right.
Oh, there's a lot of background noise there, so we're going to skip forward a little bit here. Okay.
Cannot call you as a witness, and you cannot be compelled to testify. And
Right.
I will insist you have fully investigated those, and you've either determined to use those at a trial, or you've eliminated them from consideration.
We are well aware of the consequences of this trial and have endeavored to put our case together as well as possible, which included ruling out anything unfavorable and pursuing everything favorable.
All right, ma'am, as I mentioned to your attorney before, as part of the trial strategy, you and your attorney may choose to concede all or part of one or more elements of the charge against you or the lesser included offenses. I just ask that if you discuss that, Mr. Taylor will certainly bring it to my attention, but you have every right to, and I want to make sure that you understand that those concessions are being made. Certainly stipulations of fact, you're going to sign those, so that won't be an issue. But if there's any concessions, let me know ahead of time. If it needs to be in camera, I'll be happy to do that.
Yes, sir.
All right, ma'am, so at this
Quick pause. Okay, we've got about 5 minutes left. I did want to say I added Eva's t-shirt company link, which is called Ghost Cowboy, to the description box of this live stream as well already, in case you do want to check it out.
trial, we're going to have a jury, as you heard. It'll be the 6 jurors plus the 3 alternates. Each side will have 10 strikes, peremptory strikes. And I'm sure your attorney is going to talk about cause challenges and peremptory challenges. I do talk about that a little bit more during the actual, or right before the actual jury selection process, so I'll explain that then. The state's going to be required to prove your guilt on this charge or any lesser included offenses beyond a reasonable doubt. Any affirmative defenses, such as self-defense, will be your obligation to present competent substantial evidence of those. Then the burden will shift back to the state to prove beyond a reasonable doubt that those affirmative defenses don't apply or shouldn't be applied. If there's any witnesses that you want to appear in court, you certainly have the right and the ability to compel their attendance through the power of a subpoena. Mr. Taylor, I'm sure you've issued subpoenas already, and if there's more or others, ma'am, please work with your attorney on that. He can issue subpoenas to them to call them to court. If they fail or refuse to appear, you'll have the power of the court through contempt proceedings or orders to show cause and contempt proceedings to compel them to appear. Through your attorney, you'll have every right to confront and cross-examine the witnesses against you. And ultimately, and we're going to talk much more about this later, I have an entire conversation we'll have about whether you want to testify or not testify. And that's one of the most fundamental and basic rights that you have under both the Florida and the federal Constitution, is not to be a witness in this matter. As you'll see and hear me say later on, the state cannot call you as a witness, and you cannot be compelled to testify. And I will instruct the jury multiple times during jury selection, during the preliminary instructions, during the final and the closing instructions. They're going to be told multiple times that you do not have to testify, and they cannot hold that against you in any way, and it can't let it affect their verdict in any way.
Also, please come back tomorrow for part 3. We're going to be looking at what one might call Ashley, the defendant's side of the story. We're going to see some letters that she wrote, some claims that she was stalked, you know, the domestic violence filing she made. And we're also going to look a little bit more into her supporters, the people that are like rallying for her, protesting for her outside of the courtroom, all wearing purple, of course, in honor, I guess, of domestic violence, right? Raising awareness. So please come back for part 3 tomorrow so that we can discuss that side of the story as well.
Ultimately, the decision whether to testify or not will be your decision and your decision alone after you speak with your attorneys. And we'll have that conversation once the state has rested its case, and as the defense is or isn't presenting its case, we'll have a longer conversation. All right, ma'am, did you understand all of that, everything we talked about?
I believe so, Your Honor.
Do you have any questions for me that I can answer before I finish up for today?
Not at the moment, Your Honor.
Okay. If you had questions, would you ask them? That's all I ask. Believe it or not, some people are nervous and they're scared to ask questions. And when I'm taking a plea, I'll say this. If you have any questions, and that's what I'll say. If you have questions, would you ask them? Because I want to make sure that you feel comfortable that if you have them, you'll ask them.
Most likely, Your Honor, she would direct that to me, and I would in turn ask the court.
Sure. Okay. Is there anything else? Now, I've got a check mark next to everything that I had on my list. Did we get it all?
I have just 2 very brief things for the court.
Of course.
Not to offend the court, but I am considering, and I will address it later this afternoon, a potential writ of cert based on the court's decision to not allow Mr. O'Keefe to assist me. And as a result, if the court would consider with some alacrity reducing that to a written order, 1 sentence is fine, I would appreciate it.
Sure.
The second question I have is a lot more mundane. When approximately does the court like to take its breaks, in the morning and the afternoon? And how long does the court generally break for lunch?
Oh, okay. The mid-morning, mid-afternoon breaks, I call them the comfort breaks. They're usually happening around, somewhere between 9:45 and 10:15, and they're 15 minutes. The lunch break really depends on how things are going. It can be anywhere from 1 full hour to an hour and a half.
Very good. Thank you, Your Honor.
You know what I didn't rule on, though, on your request for Mr. O'Keefe to sit at counsel table? You had mentioned, and I completely forgot to address this, and I'm glad you said that, brought that back up. You had also argued paragraph 11 of your request was the only viable option, otherwise would be for Ms. Benefield to submit a declaration of indigency and have the court appoint co-counsel. There is no case law or bases for that in the motion, in the request, and I didn't hear any argued today. I am without knowledge of, and I could have sworn the statute specifically says that the public defender shall not represent someone who is represented by privately retained counsel. I've got it in my head that that's somewhere in the statute. Maybe I read that in the JAC.
That's accurate.
Okay. So denied on that point as well. Sit there. Okay, does that take care of everything for today?
I'm done.
All right, so unless I hear from you differently, I will see you 8:30 right here Monday morning.
Yes, sir.
And do you anticipate we're going to be in this courtroom?
Yes.
Okay.
So that's starting on Monday, July 22nd is when this trial begins with jury selection, okay? So we just saw some little bits today of the pretrial hearing that took place yesterday. It was 5 hours and 7 minutes long, including a little bit of a break. So I defluffed it for us and just brought you some key points, of course. Let me just do this. So if you want to watch the full pretrial hearing, it is on Law and Crime Network on Court TV. So if you want to check it out there, I'm going to link the full one for you. You must hear how the defense attorney, he just mentioned it there now, how he wants, I think it's the previous attorney that Ashley Benefield had. He wants him to help him out with like his presentations. And he says if he doesn't have his help, it's going to just like take long. And he needs him there. And he doesn't know why the judge wouldn't have let him be there. But like, dude, you've had so much time to prepare for this. You can't just be like, bring him in. He's not going to distract anyone or do anything. He's just going to help me with my presentations. Oh dear. And thank you so much for your $3 super sticker. I really appreciate that very much. I hope you guys can hear me. I hope I'm not too soft compared to the footage that I just boosted there for you. So that was part 2. Okay, I don't want to make it too long today. It's already over 2 hours. Damn it. At least we're not here for like 5.5 or 6 hours today, which we could have been if we watched the whole thing together. That's why I just wanted to bring you the highlights. So today, if you missed it, if you only joined late, we did a recap of the case, just the bullet points of like kind of what we're looking at. But if you want to see a full deep dive, you got to check out part 1, which also includes the probable cause affidavit and hearing from Doug Benefield, the victim's biological daughter, who it sounds like Ashley Benefield was very jealous of as well. A lot of the fights were about Eva, which is actually also very unfortunate because Eva was only 15 years old when Doug and Ashley met. 15, you know? So to fight over the 15-year-old there is ridiculous. And of course, Doug, the dad, was naturally very protective of his daughter. So, and she was only 18 when her dad was shot. And that was quite soon after her mom had died, you know, all of that. That's a lot. So if you want to hear Eva's story as well, it's in part 1. So today we did a recap of the case. We also looked at what's happening outside the courtroom. We heard some clips of the 911 call that the jury won't be hearing. And we watched key moments of the pre-trial hearing, all defluffed for you. We're also going to cover the trial here in a defluffed way. If you don't know what that is, if you're brand new here, it means that we don't want to sit around through all the fluff. And by that, I mean all the paper flapping, all the long breaks, the coffee breaks, the lunch breaks, and just look at ceiling fans until we go insane. No. So we're just going to start later. Every day we'll start like 2 hours later. So don't worry if you come to the chat like, oh my God, it started. No, of course it started. We're starting 2 hours later so that we could just catch up. We could just like skip over lunch and coffee breaks and stuff, okay? So thank you so much for being here. As I say, if you haven't seen part 1, go check it out, and then you'll know who Eva is, and then you can also support her creations if you want to. I'll put her link in the description box as well, because people are asking how can we support her. And then I will see you for part 3 tomorrow, where we're going to be looking at why does Ashley Benefield have such a large group of supporters, of protesters, of people rallying outside of the courtroom? You know, what's her side of the story? What has she relayed? Is there any evidence to suggest, you know, that she was a victim of domestic violence or anything like that? Although the judge has made it clear this is not a battered spouse syndrome case. It's not a DV case. It's a homicide case. She's charged with second-degree murder, and she faces 25 to life if convicted. But nevertheless, it's going to be a very interesting trial. So I look forward to watching it with you. See you tomorrow for part 3. And then obviously I'll be seeing you next week, of course, every day from when they start for the trial. So that's what we're doing. That's the plan. Thank you so much, everyone. Thank you, mods. Thank you, everyone who supported the channel. I also want to thank everyone who sends PayPals and coffees and all of that. That is so sweet and so supportive. If you want to check out my website, it's grizzlytruecrime.com. And now I'm going to go chug a whole lot of water. I'm so thirsty. It's so hot. Hope that you guys are okay. I'm going to drink a lot of water, and I'm going to see you tomorrow. All right, everyone. Stay safe. Bye.